Well, thank you again for inviting me. It's really great to be able to come and present on this work, digital transparency by default. Um, so I think fundamentally, this is really I'm really trying to simplify the topic a lot because the point really of digital transparency by default is really to simplify digital privacy with standards. So the question really is digital privacy possible without transparency by default? So it's sort of a fundamental question, of whether or not, if we can't see what our privacy is, and if nobody knows what rights we have at any one time, then, can we access, do we actually have any privacy? So this digital transparency by default is a pattern designed to address that challenge. So in this presentation today, I'll be presenting not only digital transparency by default, but I'm going to try to be ambitious and cover what we're calling a glass box meta governance model for active state privacy patterns. And for this, we're going to cover the ANCR transparency performance indicators, which is a newly published recommendation from the Kantara Initiative. We're going to cover the operational privacy notice pattern and the anchored notice and consent receipt exchange pattern for digital twin transparency and consent. And then hopefully get to 27560 ANCR information structure profile. So the purpose of what I'm trying to really get through today with this privacy model is just to establish that digital transparency by default is a universally required pattern and model for standardization. So it's suitable for standardization because it's universally required. And in that context, present the digital privacy transparency glassbox privacy meta governance model. So it's a bit of a paradigm shift, and I think it's really sort of important to see if I can communicate that in the right way. But then we're going to present the privacy patterns for how privacy law and regulation can govern digital identification and AI. We're going to touch on AI and present the open ANCR implementation patterns. So there we go. About me, I've been, working in this space for 25 years and doing a lot of research over this time. So a lot of this work. So I'm kind of came out with the ANCR work group consent receipt specification, which was adopted by ISO as 27560 consent record information structure. And I represent Canada as privacy and identity management and trust experts. Been a founding member of the W3 Data Privacy Vocabulary Group, which I believe was previously on Eclipse and presented here. And currently working on the Global Digital Transparency Alliance and at the Digital Transparency Lab. So there's a long history here on this work, and I'm just sort of referencing it because so I can go back to it maybe perhaps a couple of times. But there's been a lot of sort of milestones, and after sort of a lot of work, we actually came up with a solution for consent receipts over 10 years ago. But after all of that, we realized that even though we might have won sort of a popular industry vote for identity management, that we needed laws to change and we needed standards. And we didn't know at the time that we needed the laws to go, to be defended and sort of or challenged in courts, like the Transparency and Consent Framework. And also we needed the standard to be an internationally open standard for it to be usable for digital transparency by default on the internet. So, there's a lot of waiting with this work over the last sort of 10 years, and sort of a lot of development through the data privacy vocabulary work group. So what is digital transparency by default? It's a core pattern, simplified privacy and data protection. And it's practice of making a record of notice activity. So ultimately, notice is required legally in all privacy instruments in all jurisdictions, and it's the most consistently defined of all the legal requirements. So regardless of the legal basis, so even if it's not consent, notice is still required. And let's see. Yeah, so the concept really is by making digital transparent default, what we're talking about is in all of the jurisdictions, a controller record is required. So a controller identity is required with their name, address, location, as well as access to privacy rights. So this is very consistent in all the jurisdictions. So the latest work we did, so the notice by default legal requirements, just covering some of those. So this here is from a report for DIAC, which is the Digital Identity Authentication Council of Canada. And this report really looked at what were the transparency and accountability requirements for notice requirements across the GDPR, PIPEDA, and PCTF, which is the Pan-Canadian Trust Framework. And you can see that there's a lot of notice requirements, but that they're required maybe internationally, but they're not required nationally, and that a lot of the practices aren't adequate. So we did this report, which really looked at what were the notice requirements for digital wallets to be internationally interoperable and to be able to use consent and to be compliant with the GDPR. So that report is available to be looked at. So the ANCR Transparency and Performance Indicator Report, which is really not spelled out very well there, is what we published out of the Kantara Initiative. And this has 4 transparency performance indicators. And this is a tool that enabled us to look at whether or not digital trust is compliant or has valid consent. And really what the practice is we have a standardized PI controller record, which is one of the specifications out of the Kantara Initiative. Really, it's the core schema behind the consent receipt. And we capture what notices and text is being provided by a controller in any context. And we fill in this controller record. And we see, we check what the timing of the notice is, if it's provided before, if the controller information is provided before information is being collected. We check whether or not the controller information is complete, whether or not it's operational, so if you could use it, and then if you can use it in context, or do you have to send an email, is it out of context? And then the third one is the access. So can you access your privacy rights, and how difficult is that to do, and how long does it take? And the fourth one is security and sovereignty. So really we're looking at the SSL certificate or a token, and we're looking to see what where the location is, what the scope of the disclosure is, and if data is traveling internationally, and if there's a notice for that. So with that, we can tell if we can do a lot of analysis from this, but we can really look at the compliance and conformance, so we can make transparent the active digital privacy state. So the ANCR TPI report, really what it does is it makes a record of the active privacy state, and we would be able to use this for to I guess look at the conformance and the compliance of consent and transparency online. So we did try this out, and we tested this out with a TPI reports for complaints versus Google Chrome. We're looking at necessary cookie, and we're just trying this out on the Chrome browser. And we found, non-surprisingly, that there's a lack of notice. When you install the application, there's no controller information. The browser identifies people without notice. And so really, there's a lot of issues with the lack of transparency and misinformation in browsers. So that's sort of our work on making the tools for transparency for global privacy rights, as well as for transparency by default. And through this work, we learned a lot. And one of the things we learned is that there's limits to data protection. So data protection principles were really developed in the 1960s. I'm not sure if people are aware of the 1967 Helsinki Declaration, which is when explicit consent was formalized for healthcare. So this was around when the principles were made and legislation was developed for the first time, and it was many years before the internet. So in data protection, all of the tools, the opt-in and opt-out, are really designed and meant for in-person physical privacy, not designed for international or internet-based privacy. So there really isn't in data protection law like identifiers or the concept of permissions. Originally, consent included the concept of notice, and identity and identification was all done in person. So a lot of these tools, they're not proportionate or reciprocal in terms of transparency online. And the big gap really is that we can't see what the scope of disclosure is when we're using internet services automatically, like we can see in real life, in person. So there's this transparency gap. So ultimately, data protection today, when you're sending information online or over the internet, is a higher risk than it would be if it was co-regulated, or if you were able to keep your data or control your data yourself, so you didn't need to have data protection. So that really sort of turned out to be the fundamental challenge with solving some of these problems. So this model, what it has is it covers 3 vectors of data control governance. So not only data protection, which is what pretty much everything is today is under, but also co-regulation, which uses standards and standards, as well as Convention 108 Plus, which is, it's being ratified. I think there's 33 countries out of 38 needed for it to come in fully into force as a treaty, but it's been implemented by the GDPR, so it's like the international standard privacy policy. So, a sec. So overall, transparency-based governance or transparency governance models is not a new thing, and challenges in governance are not new either. It goes back to governing kings and barons in the Magna Carta is really well known, but the lesser known Forest Charter in 1217 required barons to put signs up at the entrance to forests, so people knew what the land rights were, and because of that, they were able to reclaim rights back to the land. So this is the very similar pattern that happened again in the late 1800s with robber barons and big banking magnates, and it caused a crash, market crash. And again, transparency regulation came in, and in banking, the Security and Exchange Commission, officers are required to regulate and monitor banking. So it's a very common I think, it's a common pattern and challenge that, has been addressed in the past. And today we're with the data barons, we're seeing again, a lack of transparency, and we don't know what our rights are before we get into sharing data. So legal guidelines for notice in the GDPR and transparency come from the Article 29 guidelines. And these are the first 5 recitals, and I think that's just fabulous. Just in making it clear that transparency is an overarching obligation, and that it's a fundamental aspect of all the principles. And that I really like the concept of transparency in the GDPR is supposed to be user-centric rather than legalistic. So it's not, intended to be only installed and controlled by data controllers. So, and recital 5, I think, is super important in that regardless of the legal basis, the GDPR transparency requirements apply. So how do we implement or integrate transparency by default? And what's proposed here and what's presented here is to prioritize the principle of transparency. So you can see here in 29-100 privacy principles that we updated, in this model, we take the principle number 7 and we move it to number 1, so that openness, transparency, and notice is first. And then this is used to prioritize and operationalize and also align with laws and for legal compliance. And for example, Canadian's Digital Charter also has transparency. So, whether or not we can get the Digital Charter updated, I don't know. But for example, this is how this could align as a horizontal standard at a national level, but this is also aligns with Convention 108 at an international level. So we're really, I think, unique in looking at this model as far as conformance and compliance. And I get to plug, I guess, 27564 a little bit there, in that, I was quite happy to see in that privacy model at 7.2, they actually have transparency as an example of what could be a horizontal standard. So that being said, here is the glass boxed meta model, and it's consists of 6 lawful bases, 3 vectors of data control governance, as well as 4 levels of digital privacy risk assurance. But I'm not sure if you can really see here. It's framed by a code of conduct and a transparency code of practice. So in this meta model, transparency by default is the code of practice that we're referring to, and the code of conduct is really referring to the legal requirements that are operationalized, which we're familiar with. Controller identity needs to be presented or provided, organizations to be open, and that's basically what frames the glass box model. So there's sort of 72 different configurations, if you will, depending on whether or not it's data protection, or if it's personal data control, or if it's co-regulated. So I think also really worthy to note is that for each 3 vectors of data governance, there's different semantics. So most of the laws and standards are written for the data controller in the data protection context. So you can update those laws, but the semantics aren't quite the same. And really, the trust is relative to the stakeholders. So it's who defines the purpose. It really sort of changes the configuration of rights and obligations. So right now, it's pretty much data protection, and the controller has to define the purpose. And then there's a lot of these secondary purposes. In this model, all those secondary purposes are permissions. And how this works as in terms of transparency is is that you can use this as a baseline to see what the digital privacy transparency is according to the international, but also to the national standards. So you would take a regional or a national privacy law, and you can map it to this baseline, and then you can also see how that law could compare against other laws in other jurisdictions, because this uses the international instruments. And as you can see here, it's based on Council of Europe 108 plus, ISO 29100, 27560, the W3C data privacy vocabulary, and W3C verifiable credentials. There is a note in here why 29184 isn't used in here, and the consent receipt was originally appeared at ISO in the 29184 Appendix B, but 29184 was pre-GDPR, first of all. It's not open, so it's not usable as open infrastructure for digital public infrastructure, and it's not authoritative anymore. So what is authoritative is the law, but it's still very useful. So this just covers 4 levels of identification, assurance, transparency, and trust assurance, and the 3 vectors a bit more. I'm going to skip over that because of time, and get to the fun stuff. So the first pattern I'm very excited to share. So I'll just pause there. I'm not sure if there's any questions, but it's a good time. So to explain that these patterns are for this co-regulated model. So considering 3 vectors of data governance and not just the data protection. So in this privacy pattern, this is, it's been called a 2-factor notice, but really it's a notice that when you interact with it, it creates a record that you've interacted with the notice, and that record can also be shared as a receipt. So it's a twinned record that you have looked at a notice, and the initial notice or the missing notice for digital is really the controller ID and the access point. But what we can infer from that is really what the legal basis is for processing, and what's the scope of disclosure. So is my data going to stay local, or is it going to go international? And what is so I mean, with those information, so before you even know who the controller is digitally, before you want to know how is your data going to be governed, how far is your data going to be shared, and with just those 2 elements, you can get a sense of what your digital privacy risk is. So the missing risk pattern that we bring to bear here is scope of disclosure, and that's something that can be included in consent. Yeah, so that's how we look at digital twinning of transparency. Yeah, I think there's a lot of things I can say about consent receipts, but I'm not going to. Oops, this is cut off a bit. But yeah, this is the information schema or the information structure behind this, and I can get into that more later. And so this schema was originally published in 2019, but this is the core schema behind the consent receipt. And we did a lot of research to find out what were the actual requirements that were required across all jurisdictions. So I think that's what's significant here, is that the controller ID, the controller name, the language, and a notice and a privacy access point is required across all jurisdictions for digital and physical privacy. So it's something that can be standardized. So the next pattern is the anchored notice of consent receipt exchange pattern. So right now on the left, you can see we have current security is that we have user IDs, and you go to a website and you give your data to a website, and then they give you access, and that data is shared. Your user ID is literally in the header of of uh, that's sent, and is sent to like Facebook and Google and IAB. But really, like, real-time bidding can happen. So it's black boxed instead of glass box, and you're getting real-time transparency, but it's not for the user's benefits. It's for commercial benefits. So the anchored notice of consent receipt sequence is different in that you pull a notice receipt from the controller. So you're using the controller ID, and now you're unlinked. So you're initially not identified or need to be identified in order to engage with a service provider or access your rights. Right now, you have to be identified to access your rights. So this changes things quite a bit, because if you're using a controller ID and not a user ID, then you can then self-identify, and you can send that receipt back to the controller with permission, for example, for reuse of an IP address or for a profile, but also to start a engagement. So instead of signing into a contract right away to join a website, even though you might be a child, you can use privacy notice, and then you can receive the notice on your device. You can fill it in the consent form personally, and then you could also send it back. And so, yeah, so you're using a controller ID, and it's not shared on the internet. So this is the next pattern, and this is the putting those two together. So it's the operational privacy notice and the anchored notice of consent exchange. And after a couple of passes back, so the first thing you receive is a notice receipt, and there might be no state or status the first time you ever engage with that controller, and then you return that receipt, and you can return permission to process your data, and then you could also return personal information or not, but that controller can then sign that. When you return that information, it's a consent receipt. So that's a consent notice receipt, which is the second use of the receipt. And then that can be signed by the controller, and it would then be a micro-credential. So this is when it goes from a receipt to a micro-credential, which could then be reused. So the next time you go to, let's say you go to a new controller, you pull a receipt, and when you return that receipt, you can return a receipt with a micro-credential in it instead of personal information. So you can interact, effectively anonymously with a service provider, and they can take that receipt and use it as a consent token, and go to the third party or the first controller and say, is this person verifiable, or they say they're above 18, or whatever the attribute might be. So this is a negotiation, I guess, and it's a way to arrange authentication and verification through third-party services. So the same process and the same pattern for dynamic consent can also be used for dynamic lawful access. So regardless of whether or not you're the police, or you're the data subject, or you're a PI principal who may or may not be the data subject, you're still reading a notice with consent, and you're still, as an individual, maybe acting as an employee, you're still consenting to let's say, dynamically access someone's data. So in this regard, there's a third part. So let's say the police wanted to get access to your information. They would need to have the authority to do so. So in this model, it's imagined that a data privacy officer, for example, for the police department, would stamp or sign your receipt to then be able to permit you to go to a data controller and access data about an individual dynamically. So this is how you make consent tokens and effectively digitally twinning consent. And I was really excited to be able to share that with Antonio. So what can you do also, I guess, when you modernize digital privacy transparency and you use that previous pattern for consent tokens, all of a sudden dramatically reduce the need or even eliminate the need for some privacy principles. Because collection limitation is done by the third party. Let's say it's an authoritative source or your bank. So your bank is in charge of your data minimization now, and instead they're just verifying your attributes. So you don't need to worry about that. And data isn't even collected by, the first data controller. For example, you can be anonymous and you can just use authoritative sources like a bank or passport office instead of all of these third-party intermediaries. Of course, your accuracy and quality you can control, and you don't need to be granted individual participation and access because you can control your participation access yourself. So it's a much more secure way to interact online, and it's using the same identity management technologies that are used in other trust frameworks and models, but for the individual. So you can imagine that this can be extended one step further where the individual has their own wallet. So if you have your own wallet, which is, let's say it's a consent wallet instead of a digital identification wallet, you would have all of these receipts from every digital interaction in there. And so when you get a receipt directly from a notice, it's clean AI data. So it's data the individual can trust because they've read the notice and they've got that record. And that record is held privately. So now you have your own private data to use AI technology with. And that means anytime you were to use an AI technology, let's say like we're using it now, you would at least have a receipt or a record of what you're putting into it. And the AI would have this too. So there would be a record of provenance inside the knowledge model. And this is what's been missing, is this transparency over the ethics of where has this data come from. So, fundamentally, this is a security problem, and the security is over secondary purpose of use. So the key, I guess, innovation really here is to enable people to control the secondary purpose of use, enable the data silos to be opened by people with the consent tokens, and to control training. So training wouldn't be possible without permission, and you would be able to see when your data is being processed down the supply chain using this model. So really, it sort of flips the model around. And from this perspective, I think it's a lot easier to see how AI can be governed at scale, but not only that, but how you can assure that the knowledge or the LLM or the knowledge in an AI is actually qualified or capable, to do the task that it's supposed to do. So I think that's one of the key elements that's missing right now. So I'm not sure I'm doing on time, but I think I'm up out of time. But I get to the most important part I'll run through really just really fast is the 27560 consent record structure. So it was adopted to ISO, but it's sort of interpreted as a data protection standard. And so right now, the current standard actually has a PI principal ID in the header, which effectively means that it can't be a consent record information structure because the individual has already been identified before we get to the record. It also introduces party identifications, which really in the schema we're promoting, it would use a controller identification, and it would also only use a PI controller role. So the PI controller might be a third-party controller, or it might be a joint controller, but there wouldn't be a new role or entity called a party ID. So I just kind of cover over that here, and I think so. This is what presenting as the glass box model, which is a notice receipt really for all contexts. So you can use it secretly or privately, which is the red one where you just have your own record, or you can use it now, which is the yellow one, which is getting how we use it today. The green here is a consent receipt, and that is how we can remotely or decentralize data governance with consent. So and all of that can be done with the same receipt. And regardless of the legal justification, you should be able to consent for a secondary purpose of use. So unless legally the individual is not allowed to have a notice, and that notice should be given to a regulator, then we should get a receipt, and that receipt can be used for consent, regardless of whether or not the legal justification originally was consent. So, and this is, one of the ways, or one of the key ways in which you decentralize data governance and make it possible for this to be regulated online. Because without decentralization, it's not possible for regulators to actually regulate and enforce digital privacy at scale. So that's it. Sorry for running over there. I didn't realize I ran on a bit too long. But that's the entire model and all the privacy patterns.